Today we will be talking about upcoming events for Matt. New cannabis law updates. I've been getting some questions about that. So I'll go over a little bit. And then also paid leave, the new paid leave law in Minnesota, updates and questions that I've been getting on that. And then once we go through that, I have also been getting a lot of questions regarding drainage, ditches, and culverts because of the flooding. So I'll just kind of go through the most common question I've been receiving, and we can talk about that a little bit as well. All right, so the first thing is the district meetings. That's the next event coming up here for Matt. Here's a schedule for the district meetings, so make sure to attend those for your district. If you have questions about where specifically that meeting will be held, we have that information on our website under the news and events section on the homepage. Obviously, if you can't find it, contact me and I'll point it out to you, send it to you, whatever you need. There will also be information on there as to whether there's a election at that meeting. So that's where you can find that information. And then we'll get started on the cannabis updates. So a new law enacted at the end of the 2023 legislative session legalized adult use cannabis in Minnesota and established a framework over the Minnesota cannabis industry. So possession, use, and home growth under this law became legal on August 1st of 2023. And legal sales are expected to begin in January of 2025. So that's kind of an overview of that law if you missed that information. But we have been getting questions from townships regarding the new cannabis law because they are hearing from their counties that they have to pass an ordinance of some kind, or getting questions from the county. The new legislation prevents local units of government from prohibiting the establishment or operation of licensed cannabis businesses. This includes the farming and growth of cannabis products. So a town can adopt reasonable restrictions on the time, place, and manner of the operation of a cannabis business, provided that such restrictions don't prohibit the establishment and operation of the cannabis business. But that usually involves zoning ordinances if you have that, or working with an attorney to kind of regulate that within a zoning ordinance. And if you hear from your county, don't panic or overthink it. The townships really have no control or authority over this law and regulation. So there's no role that you need to play in this. The county has more of a role than the townships do. So there's not much the township can do unless they have a zoning ordinance or plan to have a zoning ordinance. Then they can choose to make changes to that, which would require the help of your town attorney if you have one of those and if you are interested. So that's really the only regulation power that a town would have. The cannabis law is not something the townships can opt into or must opt out of with any ordinance. So if you receive information from the county, if you have questions, give me a call. But for some reason, we've been getting concerns from townships saying that their county is asking them to pass an ordinance when really that is not necessary. So if your town adopted an interim ordinance, which was an option under the regulation to regulate, restrict, or prohibit the operation of a cannabis business, that is effective until January of 2025. So those ordinances were kind of, if the town was conducting studies or had conducted studies to have reasonable restrictions on the time, place, and manner of the operation of the cannabis business, then they could have an interim ordinance, but those will be effective until January 1st of 2025. So the cannabis law is not something that you need an ordinance for. You don't need to opt into it. You don't need to opt out of it. So if you hear from your county, if you have questions, you can give me a call. But generally, that is the county's concern, and it's not something that townships have much control over in the long run. All right, and then Minnesota paid leave. So the paid leave bill proposed by the Department of Employment and Economic Development has been passed by the legislature and signed by the governor. So that will be taking effect officially in 2026, but there are some steps that we need to take as of this year in order to make that happen. So DEED did create the Department of Employment and Economic Development, DEED. They created a FAQ page, much like the Earn Sick and Safe Time FAQ page. I tried to put the link in there, but it really just made it a jumbled mess. So if you have trouble finding it on their website, reach out to me and I can send it to you. But it's a really helpful page with a lot of good information and questions you might have about this new legislation and what you are required to do because of it. But the paid leave division will leverage the existing unemployment insurance division online to collect these detail reports from you and from other employers. So it'll just use the same unemployment insurance system that is already in place in order to collect that information because they need the same information. So they kind of make it easy on us in that way. There's no specific exemption for paid on-call firefighters or elected officials. Within that regulation, it's different than Earn Sick and Safe Time in that way. So if you would like to decide if those people are considered employees under that law, consult with your town attorney and see if for your specific scenario, they would be considered employees or not, because there is no specific exception there. All right. And then this is kind of what the next steps look like for paid leave. So I stole this right off the DEED website. It gives us really good information about what these steps look like. Starting in July, most employers will be able to submit quarterly wage detail reports to the leave program, but those first reports are not due until October 31st of this year. And those will be based off of the wages between July and September. DEED is collecting that information because they need to know when premiums are due, what percentage of wages to pay these employees, and when benefits start. They'll use that information to establish eligibility for the program and the benefit amount. So that's why they're collecting this information now, so that when it comes into effect in 2026, they have the information that they need in order to start sending out those checks to employees. So payroll deductions can start on January 2026. So that's not for a while. The first premiums need to be submitted to the state of Minnesota by April 30th of 2026. So it's not for some time here where we have to start paying the premiums into this unemployment, kind of the unemployment, but the paid leave benefits program. If you have a UI account, the unemployment insurance account, that will be automatically converted into a paid leave account. So it'll be a UI/paid leave account where you will submit those same wage detail reports using the same process. If you don't have one, you'll have to set one up. I assume most townships have one if they're working with employees, but you will need to provide the first and last name, social security number, hours worked for each employee, and wages paid. That's identical to the information already supplied for insurance information, or unemployment information. So there won't be much difference there. There's a small business exception with 30 or fewer employees that will be eligible for reduced premiums. So if you have questions about that, reach out to me and we can have a more in-depth conversation. All right, so that is kind of the paid leave overview, the updates to that. Again, it's not effective till 2026. We have some time, but this year we do have to submit the first wage detail reports. Yes, so this paid leave program, the question I got in the chat is paid leave different than vacation? So we have that Earn Sick and Safe Time requirement that just came into effect that we've talked about quite a bit. That's different than allowing vacation for whatever employees that you may have. So you have those requirements, but those are separate from this paid leave program. This is an insurance benefits program to allow for leave such as childcare, long-term leave, right? Longer-term leave, such as childcare, things along those lines. It's 12 weeks for certain circumstances, and the employer will pay 50% of those premiums. And then the state will have a fund for the rest of those premiums. So it is an insurance benefits program that, so elected people are not currently, elected people aren't specifically removed from this requirement like they are in Earn Sick and Safe Time. So they haven't gotten to that conclusion for this Minnesota paid leave program. So if you want to consider whether these elected people will be removed in your circumstance, work with your town attorney and see if in your circumstances, election judges are not removed as well. This covers almost all employees. They have to make, I think it's 5% of the minimum wage, $3,000 a year. There's a minimum that they have to make in order to be eligible to take this paid leave benefit, but election judges are not specifically exempt either. So that is the updates on paid leave. Again, if you want more information on this, it is on the DEED website. They have a big FAQ page that's really helpful. Otherwise, I can supply you with more information and kind of a rundown of what it looks like, who is a covered employee, who is a covered employer, what those premiums look like, that kind of information. I'm not going to dive into that today because I did do that for a Township Tuesday a few weeks ago, so I don't want to bore anyone who attended that one. But if you want more information on that, I'm happy to provide that for you, and just reach out and we can have a conversation. Okay, so clearing of culverts is our next topic. So I've been getting a lot of questions about blocked culverts because of these flooding scenarios that we've run into a lot. I did write an article for the Insider that goes more into depth about drainage ditches and your duties there, but specifically when it comes to blocked culverts and who is responsible for those, I've been getting a lot of that question specifically. So I thought I'd just quickly cover it here today so that you guys have that information. So first, I'll start with the Township Authority just as an overview, right? As the road authority, town boards are authorized to repair, clean out, deepen, widen, improve town road ditches for the purpose of draining public roads and preventing water from accumulating onto the road, right? Whether such work is necessary is determined by the town board, and that is up to the board when to perform that work. Improper water management will cause damage to the roads and increase your risk for liability. So it's important to make sure you are keeping up with that. This includes clearing debris, repairing damage that might impede water flow to the town's ditches and to the drainage system. So there is a question, however, of who does what, who's responsible, who's paying for these drainage systems when it's really, it's in the right of way, but it's a private drainage system. It's affecting the public roadway, but it's owned by private property. There's a little bit of ambiguity there when at first look. So we're going to talk about that a little bit. Who pays the bills? It's really a pointing fingers game of who wants to take responsibility. So we'll discuss that. So the township's responsibility, towns are responsible for township culverts under roadways, right? If it is owned and operated by the township and within the right of way, the town is likely responsible. But if the culvert is within the right of way, then the town could perform maintenance on it if needed. You want to take a look at basically, does the town have an interest in repairing the culvert? If there's no damage to the road and no safety concern from the water, the town likely has no reason to get involved with these culverts, right? If the water is damaging the road, then the town may choose to fix the culvert to address the damage to the road, to address the degree that it affects the township's right-of-way. In any case, the board's actions should be based on the town's needs and not aimed at resolving private disputes or private landowner concerns. This means that if a culvert is a part of the town's drainage system, the town installed the culvert, and the town cares to maintain it, it is likely their responsibility. But if the culvert serves only a private landowner, it's not supporting or important to the town drainage system or road water, then the town could refuse to maintain it or repair it if that is the issue. Now, I want to go over who the drainage authority is, because towns are the road authority, but drainage authority is a little bit different. So for state drainage laws, they initially had townships serve as the public drainage authority. However, that's no longer the case. Current drainage authorities include the county, the joint county, or the watershed district boards. For the few towns that have drainage ditches remaining in Minnesota, this township is still the drainage authority for maintenance of those. However, that's few and far between. So any improvements to the town drainage system should be petitioned to the county, joint county, or watershed district, because they are the drainage authority. So before you are going about a project within a drainage ditch or anything that it moves a culvert up or down, moves the elevation of a culvert, replaces the culvert in any way, those kinds of things, you want to make sure that you've connected with the proper drainage authority and had a conversation with them beforehand. Also, compliance with regulations is essential to avoid any penalties. So for any drainage projects, it's also important to loop in local soil and water conservation district offices and identify any permits that you might need or might be in play in these scenarios. So I just wanted to remind you of that as well. It's a little bit sideways from the culvert issue, but it related enough where I felt the need to bring it up. All right, so landowners. So if the landowner has a culvert, they have an approach culvert or a culvert under their driveway, it is the responsibility of the landowner to clear that approach culvert to allow drainage in the ditch. This is supported by the fact that the cost of purchasing and installing an approach culvert is placed on the landowners by Minnesota Statute 160.18. This allows the township to regulate that installation through a permit process. So Minnesota Statute 160.20 says a person can install a tile or drainage up to or across a township road, but that person must get a written permit to make the connection. So if you have not done so already, the town may want to consider implementing a right-of-way management ordinance to enforce those kinds of requirements. Once the right-of-way management ordinance is adopted, the township can inform the landowners of their responsibility, and it's a little more clear about who's responsible for what and how you can go about enforcing those responsibilities. The town board doesn't accept liability for maintenance to these culverts by the statute, but that should be made clear in these permits issued to the landowner. So once you go about this permit process, you'll make it clear that it is their responsibility to clear those out when they become clogged. Work with your town attorney to make the terms clear in these permits and with the right-of-way management ordinance. As always, you'll want to work with your town attorney when implementing these kinds of ordinances. All right. So keep in mind drainage and reasonable use. This is another aside that you just need to keep in mind when working within these drainage ditches and regarding clearing of culverts and maintaining water levels. So a town road right-of-way is a type of easement established for the purpose of transportation and access to local properties, right? That's a road. However, the right-of-way also acts as a drainage course as water just incidentally enters into and crosses the town right-of-way. That statute, Minnesota Statute 160.20, allows landowners to discharge water onto the right-of-way reasonably, in a reasonable manner. So courts will analyze the management of those surface waters between private property owners and the road authority under the reasonable use doctrine. And those four factors there on the right are kind of what they consider reasonable, or how they determine what is reasonable. And it's measured on a case-by-case basis. So when you're dealing with somebody putting water into the right-of-way from their private property, you want to assess whether it's reasonably necessary for drainage. Is there reasonable care taken to avoid unnecessary injury? Does the utility or benefit accruing to the land drained reasonably outweigh the gravity of the harm? Is the drainage accomplished by reasonably improving or aiding the normal and natural system of drainage? Or is it reasonably feasible artificial drainage system adopted? So those are the kind of the steps you want to take a look at when you're dealing with somebody who is draining water onto the road. Is it reasonable, right? So that's what the courts will take a look at. So overall, when you're dealing with these culverts and drainage systems, it can be difficult in times of flood because there's just so much water. It's hard to know where to put it and how to displace the water this way or that way. So it can be left up to a case-by-case scenario. So if you have questions on this in a particular issue in your township, please feel free to reach out and we can work through it together. But overall, work together, right? This is really a conversation that you guys should have with your township residents to try to figure that out. But when the course of natural drainage to any land runs to a road, the landowner has the right to enter the town road right of way as long as the road is left in good condition, or the same condition as when it was connected. The township can establish reasonable rules and obligations for the landowner to obtain a permit before connecting those drainage ditches to the road, and a landowner would be responsible for the maintenance of those drainage systems and their private drainage systems to clean out any clogged or private drainage system. Keep in mind, the township does not have the authority to pay for a landowner's private utility costs. So even if the township would like to help these landowners out, they don't have the ability to do so in some circumstances. So because public funds can only be spent for a public purpose. So as long as that is met, you want to pay attention to whether this is a private benefit or whether that would be a public benefit. Implementing a right-of-way ordinance or a right-of-way maintenance ordinance will help clarify who's responsible and allow you to easily enforce those statutes that we discussed earlier about the permit requirements. There are statutes, those statutes dictate what a landowner can and cannot do within the right-of-way. So it really helps to have the landowner and the township understand who's responsible for what. Any of these issues will require a cooperative approach involving the township authorities, landowners, and as I discussed earlier, the county and state agencies in some circumstances. So work together to figure this out, and you should be good to go from there, right? It's always easier when you have a conversation with everyone involved. And hopefully the flooding will be done soon. But that is all I have for you today. I don't see any questions in the chat regarding that, but if there's any now, I will take them. All right. Email or call as always with any first question in the chat. Oh, regarding the earned sick and safe time upon termination, do we have to pay the employee when in the account for them? Oh, what's in the account? What's in the account for them? So it depends on how you're paying that person or how you're documenting the earned sick and safe time, right? In some instances, if you are supplying them with earned sick and safe time in advance, doing that front loading option, you would have to, but in some circumstances you don't. So reach out to me and I can give you a more detailed answer depending on your town's scenario.
Maddie?
Yeah.
So So we have summer help for 14 and 15-year-old kids. And
Yep.
they are earning the Earn Safe, the ESST,
Mm-hmm.
because they're hourly employees. But what I'm wondering is they're only working like a month total. Do we need to pay whatever is been earned in that at the end? I mean, I'm not quite sure how this works.
Mm-hmm. So are they working 80 hours? No, then
No.
they do not need to receive the earn sick and safe time. It's a minimum of 80 hours to qualify for earn sick and safe time
Okay.
annually. So those seasonal employees who are only working for a month and maybe not working that full 80 hours requirement, they wouldn't qualify for earn sick and safe time.
But if they went over 80 hours, then we'd have to pay it?
Yes. Yep.
Okay, thank you.
Yep, you're welcome. Sorry, I missed that. I missed that first question. All right. If you have any other questions, give me a call or email me and we can work through those. Otherwise, have a wonderful week, 2 weeks, and we'll see you next time for Township Tuesday.